But today I'm really excited to interview you, Bridget, for our main topic about something that I know you and your team are really excited about, which is AI arbitrators. So in September, the American Arbitration Association, of which you are the president, made a really big announcement. So can you tell us what that announcement was?
Yeah, so thanks for the question. We announced in September that on November 3rd we are going live with the first AI arbitrator. It's something we've been working on for a long time. I will take a step back first and say, as you know, we've been building lots of kind of point solutions and then AI operations across our case management system for a few years now. We've been building things for our users, building things for our teams. And learning along the way what we could do well ourselves, what we did better with a partner, what we should just let a partner do altogether, and we were doing that to get ready for some of these bigger releases, and this is the first of those. It's an AI native case management system that this AI arbitrator works on. And it is, this first use case is just documents-only construction cases. We started with a pretty discrete case type. And it's a multi-agent architecture. I think my team says there are up to 80 agents that operate across the life of an arbitration case that goes to the AI arbitrator. And it's going to significantly reduce cost and time to resolution. And we're pretty excited for the world to see it. It's as I said, we've been working on it for about 9 or 10 months, and the team's been working incredibly hard, and we're really proud of what we built.
That's awesome. So what prompted the AAA to commit to an AI arbitrator now versus sort of more incremental AI support tools?
So we've built a lot of the support tools. We kind of are already there. Like, we already have AI support built into our legacy case management system for parties and for arbitrators, and we've been training arbitrators on how to use those tools. We do think, arbitrators of the future need to be able to bring those efficiencies to the parties who use our system. And it's an opportunity to offer just another way for parties to resolve cases. And as you might imagine, there could be users who want a mostly human-led arbitration process for certain disputes. And people always think, bet the company disputes. Well, sure, maybe, but also sometimes not bet the company disputes, but disputes where parties have to have a continuing relationship, and so they just want more human involvement along the way, because it's a relationship-saving process as much as it is a dispute resolution process. So parties should always be able to have that, and they always will be able to have that. Although even in that, we want to make sure we can bring every efficiency possible, so it gets resolved quickly and without much expense. But there'll be other disputes where two business owners might say, for these disputes that are governed by this contract, and there are only a few different ways that it can be that the dispute arises. Like, we would like to send all those immediately to an AI native option. I should have said at the top, we have a human in the loop throughout the process, and it's the parties themselves in the filing process, and I'll say more about that if you're curious. But then there's a human arbitrator. We have a panel of arbitrators trained to work on this process. At some point, if there are users who want us to unplug the human, we can definitely think about what that looks like. But for now, we want to make sure that people understand how it works, understand there's a human in the loop, and can grow confidence in it. We assume that for the first, who knows how long, number of months, we'll be getting feedback from users, and we can continue to iterate. Our engineers build in an agile way, and so we'll just continue iterating what we've built to make it, more and more what users are looking for as we go. Although we did have users testing it throughout the build, of course.
So what did that look like at the user testing phase? Who were the users?
Yeah, we recruited lawyers who use our process, and then for some of the sprints we recruited law students, law professors. We basically would recruit anybody to come try and we want you to use it as a first-time user who knows nothing about arbitration. How does it work for you? Where did you find it confusing? And it was just a way to iterate in each sprint to improve that part of the process. So lawyers, arbitrators, we had arbitrators throughout the process helping us build it as well. So yeah.
What made you gravitate toward documents-only construction cases in particular?
Yeah, I mean, so one reason is, this is a tool built on the AAA's century of experience. So we have a lot of documents-only construction awards. The construction industry uses arbitration often because they're ongoing projects and they really need to get their disputes resolved and keep moving forward with projects, and we have a wonderful relationship with the construction industry. That was important to us because we wanted to make sure that we were hearing from them throughout the build about what would be effective and how they would like to see it. But we have all this expertise and awards that we were able to turn into the handbook to train the agents that are working across the arbitration process. It's also the case that it's a fairly simple. The AI arbitrator doesn't have to listen to testimony. It doesn't even have to review transcripts of testimony. So starting simple made a lot of sense to us for our own, for what we were building, but also for users. Like, this is the kind of case that users would probably first want to experiment with it. So for lots of reasons, both our expertise, our data, and it seemed like from talking to our users, one where they were interested, even before we started, it was a good place to start.
I know they're really different contexts, but it's making me think of our conversation about Adam Unikowski's oral arguments in front of the Supreme Court and the closed universe.
The same, a closed universe
of appellate case.
Yeah.
And the briefings and.
Yeah, I mean, Adam's point is that that it can really handle arguing in an oral argument. Like, even you could imagine a state. I think we did a podcast on this one. A state intermediate appellate court. You could feed all of the briefs, even all the amicus briefs, and any record evidence that the court is allowed to consider, because that's all part of the public record, and it's a contained, closed data set. So this is sort of like that. Similar idea. Yeah.
And I would imagine a little bit less of an emotional, relationship-driven type matter.
Yeah, I mean, you never know. I've stopped predicting when people are emotional and what they're emotional about, but it is certainly a set of cases that's B2B, and people are looking to get them resolved efficiently, and so the time savings and the cost savings are definitely appealing to people. There's one more thing about it that I don't know that I appreciated at the front end, but I really now appreciate at the back end, that I think is a little bit of a game changer for giving the world like another way to resolve disputes. It's for the front end of the process, when the parties are uploading their pleadings, their evidence, any legal support that they think the arbitrator should consider, the AI arbitrator and the human arbitrator, the set of agents are talking to the parties. They're spitting it back to them in the format that they understand it. So they might take a pleading that's maybe not perfectly like written or argued, and they'll say, look, I think these are your claims. I think these are the elements of the claims. This is what the AI arbitrator will say. And this is the evidence that you have that supports those claims, and this is the law that you believe says you should win on those claims. Did I get that right? And then, the party gets to feel heard, right? The party gets to say, like, yeah, actually you did. Like, that is what I'm saying. Or, no, you missed this one important thing. There's another claim, and, it might not have been perfectly pled, but it really gives them an opportunity to make sure they were heard. And you've heard me talk a million times about the, robust academic literature on procedural fairness and procedural justice, and there's all this support for the fact that when people feel heard in a dispute resolution process, it's all done in courts, but it's no different. When they feel heard, when they feel like they were understood, that what they're complaining about, someone understood, they will take bad news. Like, you can give them a bad result, and if they feel heard and understood, they will still grow more confident in the process. And I think it's a game changer that this actually will grow parties' confidence in the process, because they'll be able to see that it understood what they were complaining about. And then when they get an award, it'll explain, here's why, here's why the answer is A and not B, and it'll. I really think that that ability to give people some assurance that they were understood is a game changer. Like, courts can't do that. Like, busy courts get a summary judgment motion and a response, and then the judge goes back with their clerk and figures it out and issues a decision. And as somebody who reviewed many of those decisions, I can't tell you how many parties would come to the Supreme Court and say, Court of Appeals didn't even rule on my third issue. What, did they stop reading? What happened?
Yeah.
So I'm really excited about it. It's just growing dispute resolution options for people, and it's going to be a pretty great offering, I think, to the menu.
But what a cool reframe! The way people think about it now is you're removing the humanity from the system.
Yeah.
But in a lot of ways, you're actually responding to the human need to be heard, because there aren't enough humans to actually hear the other humans. So finding the places where it's appropriate to be giving that, to respond to that need.
We know there are. This is the problem with the civil justice system generally. There are not enough humans to help people with civil justice problems, and there are certainly not enough humans to hear every individual person in all of those cases. Just walk into any busy docket in any courthouse in any state, and you'll see that there's no way the judge can say, well, let's sit down and let me make sure I understand every single claim and every single element and every single piece of evidence you think supports those elements, right? It's not,
it's fiction.
Yeah.
Love that. So who actually gets to decide when the AI arbitrator is used?
Parties. Like every other ADR process, parties choose it. And so, right now nobody's got it written into a contract because it's brand new. It doesn't, in the future, I assume some parties will write it into contracts, because they'll decide that for this set of contracts, we don't need, we want to go just that route. But for now, parties will have the option when they file a dispute with the AAA to choose it. Both sides have to agree. We're not all optional. But we'll have a conversation in a few months. I'll let you know how many people are choosing it.
Well, I was going to say, what is the sort of promotional outreach plan? How do people learn about it?
You mean what's the go-to-market?
Yes.
Yeah.
What is the go-to-market strategy?
Yeah. It's really interesting. Like I said, one of the reasons we chose documents in construction cases is because we have these deep and long-standing relationships with the construction industry, their lawyers, their engineers. We just have a very close relationship. We run an annual construction conference. It's always sold out. So our teams are in regular meetings with the lawyers and the companies that use our services, just to educate them about it. We have a great clickable demo. We have a great video demo. We have amazing assets to show people who are interested how it works. And we're out talking about it, and as cases start to come in after it's live, we're just going to start offering it to people. They just want to sort of see how it works, and they don't want to commit to it, but there'll be a moment to intercept people to say, you should probably check this out, because next time you might want it, or maybe you want it this time, you should check it out. I will say that I am talking about it wherever I go, and as you know, I go a lot of places and do a lot of talking. And I'm hearing from lots of, especially in-house teams in other industries, who already have identified a caseload that they're like, oh gosh, can you do it? Can you do this one next? It's perfect for supplier disputes, or it's perfect for dealer disputes. There's they can identify what caseload for them this use case would be great to have as an option. Again, they don't want to use it for everything. They definitely, want to be able to continue to use the process they used last year for certain cases, and eventually they will be able to choose their own adventure. We will replace our entire case management system by the end of 2027 with an AI native platform, and people will be able to have in their arbitrations, mediations, and any other process they want as much or as little AI native case management. So it'll be up to them. Yeah.
Across all case types?
Well, that case management system will support all case types. The AI arbitrator that can reason we're going to do that case type by case type, because we
Okay.
really need to train it on our
The
own
specific.
expertise and our data, and so that really has to be. The way I describe it is, we've trained a really awesome general arbitrator, like the first set of agents. I don't know, Diana would have to tell you whether that's 30 or 50. Are going to be excellent across the front end of any case. And then for the specific dispute type, you need an additional set of agents that are trained on the data that's relevant to that dispute type. And so that we will only roll out as we have the expertise and the data to train it.
And so do you have a sense of what the roadmap looks like for those cases?
Yeah, we do. I mean, so we have a sense of what we hope to accomplish. So we're now investigating sort of the next documents only case type, and there are a few possibilities. There's a lot in the sort of payer-provider healthcare disputes, and you see those also in a couple of no-fault caseloads. And so that'll probably be one of those will probably be the next case type. We're just talking to users right now, actually, to see what they want instead of us deciding what we want. We want to hear from the market about what they think would be a next one, and then my amazing Chief Technology Officer Diana Didia is convinced that her team can now build these, each next one a little bit faster than the last one. So she thinks we can get a number of new ones built in 2026. So
That's amazing.
yeah, it's pretty cool.